afternoon, everyone. Thank you for joining us on another episode of the Supreme Podcast. We hope you enjoyed last week's podcast where we covered Citizens United. This week, we thought it'd be interesting if we covered a controversial decision that had a lot of media attention at the time, Trump versus Hawaii, which was decided on June 26, 2018. And today we're going to be doing this in a way that we normally do it. We're going to be giving you the historical context of the issue. We're going to be giving you the facts of the case, and then we're going to be having a discussion on the opinions of the case by the Supreme Court. Our intention here is to always inform you to the greatest extent of the issues surrounding the case and the Supreme Court's ruling itself, to make you a more informed citizen of this union. Today, we're going to be doing it in a little bit of a panelist style. We'll be kicking it to different people to explain different contexts and then having the discussion at the end on the majority and the dissent, both bringing up interesting points in this case. So starting off today, I'm going to be kicking it to Addie and Sabrina, who will be giving you the history of immigration in the United States from the 20th to the 21st century. Guys, take it away.
Immigration policy in the United States during the 20th and early 21st century has remained consistent with the fact that they reflect the migrant flows and politics of the time. The United States has had a surge of immigrants since its establishment, and currently the only thing that has changed is the immigrants' native country. Many policies reflected ethnic or religious bigotry or for political and economic reasons. As the 20th century started, more anti-immigration sentiments started to grow. In the early 20th century, there were nearly 24 million immigrants that arrived. This was known as the Great Wave. When World War I occurred, it reduced the number of immigrants from Europe, and then it increased upon the end of the World War I. This caused anti-immigration sentiment to grow, and it caused a national literacy test to be adopted in 1917, along with the 1917 Immigration Act, also known as the Asiatic Barred Zone Act, which banned immigration from most Asian countries except for the Philippines and Japan. Shortly after, Congress created a new immigration policy. This was the National Origins or Emergency Quota System that was passed in 1921. This caused immigration to be limited by assigning each nationality a quota based on its representation in past U.S. Census figures, causing immigration numbers to be capped at 350,000. This quota favored those who were from Northwestern Europe. During this time, Congress created the U.S. Border Patrol within the Bureau of Immigration in 1924. Along with the creation of Border Patrol, the Immigration Act of 1924 was created, which further restricted immigration and decreased the cap from 350,000 to 165,000. This act continued to favor Western European countries, and it limited Southern European countries, and immigration from Asian countries was still barred. This act, however, placed a formal restriction on Japanese immigration. This act is perhaps one of the most stringent immigration policies around this time. Immigration started to decrease during the Great Depression and continued to remain low during the 20 years that followed World War II, and the Immigration and Nationality Act of 1952 also ensured this. Beginning in the mid-20th century, more Mexican immigrants were migrating to the United States to work in seasonal labor. This is also known as the Bracero program. There were still laws that excluded some races, such as the Magnuson Act, also known as the Chinese Exclusion Repeal Act of 1943, which established a quota of about 105 immigrants per year. However, by 1952, the Immigration and Nationality Act removed race as an exclusion for immigration and naturalization, and finally started to grant Asian countries entrance. Around this time, the United States also passed the Refugee Act of 1953, which authorized special non-quota visas for more than 200,000 refugees and allowed these immigrants to become permanent residents. Congress eventually replaced the quota system with a preference system, known as the Immigration and Nationality Act of 1965, which was designed to unite immigrant families and also attract skilled immigrants. This new bill decreased the number of immigrants coming from Northwestern Europe and had a surge of applications from Asia and Latin America. The number of immigrants arriving tripled and reached 1 million by the 21st century. This trend continued to be prevalent, and eventually the number of immigrants tripled by the 21st century, and there was 1 million immigrants per year. Things remain the same with immigration, and the United States passed the Refugee Act of 1980, which created a general policy for admission of refugees. Finally, to end off the 20th century, 3 major laws were passed. The first major one was the Immigration Reform and Control Act, which was passed in 1986, and it granted a pathway to permanent residency to undocumented workers who lived in the U.S. since 1982 or worked in certain agricultural jobs, granting approximately 2.7 million people permanent residency. The second major one was the Immigration Act of 1990. This act expanded the 1965 Act and increased the annual immigration cap to 700,000. And it retained family reunification as the major entry path. The last major act was the Illegal Immigration Reform and Immigrant Responsibility Act. This act expanded border controls by mandating the hiring of more Border Patrol and Immigration and Naturalization Service agents and the installation of fences at the southwest border. This act was intended to tighten up admissions and eligibility requirements and remove criminal and other deportable undocumented immigrants. And now I'll pass it off to Addie to finish the 21st century policies.
Thank you. Beginning the 21st century, anti-immigrant sentiment started to grow under Bush's administration. Most of this due to the terrorist attack on September 11, 2001. In response to this, in 2002, Congress passed the Homeland Security Act, which transferred nearly all functions of the United States Immigration and Naturalization Service to the new Department of Homeland Security, which includes the U.S. Custom and Border Protections, U.S. Immigration and Custom Enforcement, and U.S. Citizenship and Immigration Services, along with the law that came with Enhanced Border Security and Visa Entry Reform Act of 2002, which requires an electronic data system to be used to make available information relevant to admissions and removability of immigrants. The final act of Bush's era was the Secure Fence Act of 2006, which created the new security measures for the United States land and sea borders in order to deter illegal immigrants. This included increased staffing and new technology at the southwestern border. The main part of the act was the mandate of construction of a 700 miles long fence along the southern border with Mexico, which is still not completed. Under Obama's presidency in 2014, he established the Deferred Action for Childhood Arrivals, DACA, which resulted in renewable 2-year grants of protection from deportation, work permits, and identity documents for approximately 700,000 undocumented immigrants who arrived in the country as children if they met criteria. Along with DACA in 2014, Obama issued another executive order known as Deferred Action for Parents and Lawful Permanent Residents, DAPA. The expanded DACA and proposed delaying of the deportation of the parents of US citizens or lawful permanent residents, as well as providing them with work permits as long as they fit a certain criteria. DAPA, however, is still on a hold as it is being challenged in state courts and has yet to be implemented. As Trump took office, immigration was at the forefront of his campaign message. He made promises to build a wall and make Mexico pay for it, deport all undocumented immigrants and defund sanctuary cities, ban Muslims from entering the United States, limit legal immigration, and triple the number of ICE agents. In January 2017, Trump signed several executive orders. He issued the executive order known as the Enhancing Public Safety in the Interior of the United States, which introduced penalties against sanctuary cities, making them ineligible for federal grants, prioritized the deportation of non-citizens charged with or convicted of a crime, reinstated secure communities, a deportation program discontinued under Obama administration that used the local law enforcement data to identify undocumented individuals. Next, he established the Border Security and Immigration Enforcement Improvements. This called for the construction of a wall along United States southern border. Finally, he signed a travel ban that restricted the admission of citizens from the countries Iran, Iraq, Libya, Somalia, Sudan, Syria, and Yemen. This ultimately halted the acceptance of refugees while the order was under review. The executive was controversial and constitutionality of it was questioned in multiple federal courts. Lastly, under Trump administration, DACA and DAPA are at stake. Both are at risk of being rescinded. DACA's fate currently resides in the Supreme Court's hand, and approximately 700,000 undocumented people are at risk.
Thank you, Addie and Sabrina, for giving us more historical context on immigration policy for the United States from the 20th century to the 21st century. Before we move into the discussion of the majority and the dissent opinion in this case, we want to talk about two other important aspects and context to this case. One is the comparison from scholars that this case has been getting to one called Korematsu versus the United States, and the other is the context of the executive order of the day that is in question. So we think that highlighting those two things are important before we get into the discussion of the majority and the dissenting opinion. To start us off, we'll have Alexis talk about the case Korematsu versus the United States, which has gotten a lot of comparisons to Trump versus Hawaii. So Alexis, what do you got for us?
In 1942, President Roosevelt presented an executive order that allowed military zones to be made. These military zones could permit curfews and the removal of people for the sake of preventing spying. Congress decided to pass legislation in favor of President Roosevelt's decision. Korematsu would not leave his house, resulting in him violating an exclusion order and eventually being convicted in district court. Korematsu's conviction ended up being upheld by the Court of Appeals, and the Supreme Court granted cert. The court decided that it did not surpass the power of the legislative and executive branches of government to prohibit individuals of Japanese ancestry from parts of the West Coast throughout a time of war. Justice Hugo Black mainly discusses the need to stop espionage, stating that the government proceeded within its powers. On the other hand, Justice Roberts debates that Korematsu's constitutional rights have been violated, considering no evidence about his faithfulness to the United States of America was reviewed. Justice Murphy makes the argument that the Civilian Exclusion Order number 34 does not pass the judicial test that mostly focuses on the correlation between the deprivation of liberties and the appearance of public danger in that region. As stated by Justice Murphy, the action of the government may be considered racial discrimination, as the government has deprived Korematsu's equal protection and due process rights. Lastly, Justice Jackson focuses on the racial factors in Korematsu's case and accuses the court of misrepresenting the Constitution in order to endorse military actions. Now, Divya, can you give us a brief outline of President Trump's attempts to use executive orders to restrict immigration?
Yeah. So 1 week after his inauguration, Trump issued an executive order that limited travel of Muslims from certain countries after it was blocked by the federal courts. In March, he issued a second executive order, which was also blocked. Subsequently, in September 2017, Trump issued a third travel ban on entry of immigrants from predominantly Muslim countries like Iran, Iraq, Libya, Syria, and Yemen, as well as North Korea and Venezuela. This proclamation was also blocked by federal courts, and Trump appealed the appellate court's decision. Under the INA, foreign nationals who want to enter the country have to undergo a vetting process before entering the United States to ensure that they satisfy all of the entry requirements. The INA allows the president to restrict aliens from entering the United States if he finds that their entry would be, quote unquote, detrimental to the interests of the United States. Using this as a basis, the president deemed it necessary to impose restrictions on nationals of countries that don't satisfy all of the requirements of entry or that may pose as a national security risk. So to further expand on the executive orders that Adi brought up, here are some specifics on the orders. So on the executive order of border security, also known as Border Security and Immigration Enforcement Improvements, there was a construction of a border wall and additional border patrol personnel. So Section 4 of this Border Security Executive Order directs DHS to take steps to obtain operational control of the U.S.-Mexico border by planning, designing, and constructing a wall along the length of the border. Another part of this order is increased construction of detention facilities and detention of immigrants. So this directs DHS to immediately construct detention facilities at or near the southern border and to assign asylum officers and immigration judges to the facilities to conduct asylum interviews and hearings. The last part of this order is limiting access to asylum. So Section 11 of the order directs DHS to expand expedited removal throughout the country as opposed to within 100 miles of the border and to apply humanitarian parole authority only on a case-by-case basis. The other executive order mentioned was the Executive Order of Interior Enforcement called Enhancing Public Safety in the Interior of the United States. So one part of this is the sanctuary cities and local federal immigration enforcement. Section 9 of this forbids sanctuary jurisdictions from receiving federal grants except those that are necessary for enforcement purposes. The executive order will penalize these jurisdictions if they continue not to participate by withholding federal grant money except money for the quote-unquote enforcement purposes. Next part of this is the enforcement priorities, wherein Section 5 expands the priority list of non-citizens subject to deportation to anyone charged of a criminal offense. And lastly, there's an increase in ICE agents, where Section 7 authorizes an increase of 10,000 additional ICE agents. Combined with the 2 executive orders on immigration enforcement, provide a blueprint to use all available resources and authority to deport as many undocumented persons as possible. There's also the executive order on refugees, and otherwise known as protecting the nation from terrorist attacks by foreign nationals. So the first part of this is the suspension of visas to certain countries and extreme vetting. So Section 3 of the executive order suspends the issuance of visas to countries designated as being detrimental to the interests of the United States for 90 days, listing Iran, Iraq, Sudan, Syria, Libya, Somalia, and Yemen. And then there's the suspension of the U.S. refugee program and the ban on Syrian refugees. And Section 5 of this executive order suspends the U.S. resettlement program for 120 days while a review is made to ensure that refugees are being adequately screened for national security purposes. In addition, it suspends the resettlement of Syrian refugees indefinitely. Now, Philip, could you further provide a review of the court's decision in Trump's executive orders?
Well, guys, thank you so much for providing us that in-depth context and background to the leading up to this case. Our audience very much appreciates it. Now we'd like to throw it out to our panel to ask questions so that we can get into the dissent and the majority opinion in this case, because we want to answer as many questions as we can and really dig into the Supreme Court's ruling. So we're now going to open it up to questions.
Okay, so I have a question. So my question is that how did the Supreme Court rule on whether the Immigration and Nationality gave power to the president to issue the 3rd executive order?
Well, I think that's a good question, and I will be talking for the majority opinion written by John Roberts. And so what the court does for the majority opinion is they look at whether or not there was a legitimate purpose for the exclusion. And they look at whether they don't look at the legitimate purpose. They look at the means by which it's done. So in the INA, they mostly cite Section 1182F, which grants the president a broad discretion to suspend entry of aliens into the United States. And what it does, it rests not only the ability to ban aliens from entering the United States, but it also allows the president to determine whether or not there is a threat to the United States interest. And the section reads as, whenever the president finds that the entry of any aliens or any of the class of aliens into the United States would be detrimental to the interest of the United States, he may by proclamation and for such period as he shall deem necessary suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he deem to be appropriate. So essentially, the INA, which was passed by Congress and signed by the president being a legitimate law, gives the president the power in foreign policy to determine for the interest of the nation whether or not the entry of a specific group would be a threat to the United States interest. And therefore, by that logic, the Supreme Court rules that the president had a lawful execution of the power that was invested in him by the act.
So I have another question. How did the majority and dissent rule on the Establishment Clause of the First Amendment?
Yeah, I can definitely touch on that first, since we first talked about the majority opinion. So Justice Sotomayor is the one to dissent in Trump v. Hawaii, and she starts her dissent by discussing the First Amendment, more specifically the Establishment Clause. And for Sotomayor, she quotes, "The clearest command of the Establishment Clause is that the government cannot favor or disfavor one religion over another," end quote. And she then further kind of explains that reasoning. She says that after she reviewed all of the evidence and, took into consideration all of her other justices' opinions, she quotes that the review of all of the evidence, quote, would lead a reasonable observer to conclude that Executive Order 3 was motivated by anti-Muslim animus, end quote. So And then she goes further and says that the sympathetic observer, it's not just a sympathetic observer that would come to this conclusion. It's a reasonable observer. And from how I see it, she's saying that this conclusion of her quoting that it's going to be a reasonable observer's conclusion isn't just because she's a Supreme Court justice, or she's kind of just saying that my argument here is not an emotionally driven one. And if Philip, do you want to talk about what the court majority
I could touch on that.
The First Amendment?
Yeah, in the majority opinion, John Roberts details really three main points as to why it doesn't violate the Establishment Clause of the First Amendment. And the Establishment Clause means that no religion will be favored more than the other by the federal government or state governments. And he says that the text in itself, the executive order, never mentions any religion. There's never a mention of Islam. There's no mention of Judaism. There's no mention of Christianity. There is no mention of any religion in the entire executive order. And the next thing he mentions is that although they are 6 of the 8 countries are mostly Muslim, they only cover 8% of the Muslims' world population. And by that reasoning, he says that it's not targeting Muslim. It's not targeting Islam as a religion per se in his decision. And he also says that the decision was not based on religion. It was more based on countries that were limited, countries that were already designated by Congress by previous administrations as security risks, and that he cites that as the primary factor for which it is, and not the religion. And so for John Roberts, he looks at it as more of the national security risk from the 8 countries that are listed, rather than it being one religion being favored over the other, despite 6 of the countries being majority Muslim. And that was the rationale of the first on that question about whether or not, how they ruled on the first establishment, is that they said it didn't violate the First Amendment Establishment Clause.
My question is, what precedent was used to inform the dissent and the majority?
Well, it's actually pretty interesting what the majority cites as for precedent. So they turn to a case that I'm going to butcher the name on. It's Kleindest versus Mandel, and in this case, the Attorney General denied admission to a Belgian journalist who was a self-proclaimed revolutionary Marxist, and in that case, in the decision they acknowledged the First Amendment right to receive information, but they limited their review to whether the executive gave factually legitimate and bona fide reasons for the action. That's how they phrased it. And so Mandel's outcome was really that judicial inquiry into national security realm raises concerns for separation of powers and intrudes on the president's constitutional responsibilities. So what they said was they couldn't actually determine what the effectiveness of the ban was. They couldn't get into like the political nature of the question. They could only determine the legal and constitutional application of it. And they also found that any constitutional law that would inhibit the flexibility of the president to respond to the changing world conditions, because the world's ever changing, any of those that are adopted should be adopted with great caution. And so that's kind of what they used to guide their precedent, in which they decided that they couldn't rule on the effectiveness of the ban that Trump had placed. They couldn't rule on that question because of the fact that the precedent of Mandel they had earlier.
Yeah, and for Justice Sotomayor in her dissent, she is comparing Trump's, hostility against Islam with the court's recent ruling in Masterpiece Cake Shop v. Colorado Civil Rights Commission. And that case notes that, quote, the court recently found less pervasive official expressions of hostility and the failure to disavow them to be constitutionally significant, end quote. And her dissent is saying that, the executive orders in this case are being really hostile towards North Koreans, Muslims, and Venezuelans in a really indirect way, but they got around it by being less pervasive.
Yeah, and I think the precedent also is looked at by the majority in the same vein, but they come to a different conclusion. So they say that usually with these kind of orders, the only way they're struck down is if there's a common thread of targeting a politically unpopular group, But they say the majority actually comes to the conclusion that the proclamation by the president didn't fit this pattern. They actually say that it was invested in a national security concern that's apart from religious hostility, looking at the history of like Supreme Court rulings. So they kind of look at the majority looks at that opinion that like same lens, but they come to a different conclusion, which I think is interesting.
Yes, for sure.
Okay, I have one last final question. How is the court case decision different from the controversial decision in Korematsu?
Phil, do you
Well,
want to start? Or?
Yeah, I can go first. The majority doesn't actually say as much, so I'll let the dissent kind of go through the lineage of things they talk about, because they talk about a lot of stuff. Really, John Roberts just kind of outlines a couple of ways that this is different. He first says that the president in Korematsu acted outside the scope of his authority, which is not true in this case, since the INA gave the president the authority to instigate this ban. He says that the president was acting within legal authority, while FDR was not acting in the same legal framework. He also says that there was the relocation in Korematsu was clearly based on race. I think it's even mentioned in Korematsu itself that they talk, like in the proclamation by FDR, that it's specifically targeting ancestors of Japanese descent. And he says that in this case, there isn't that same specific targeting of race as there was in Korematsu. But the biggest point he makes is that he says EOC is a neutral policy involving admission of foreign nationals, while Korematsu is currently based on people who are living in the United States and American citizens. But in this case, it's a foreign policy, which is usually invested in the authority of the executive branch, which is how he draws the distinction between Korematsu and Trump versus Hawaii.
Yeah, and Justice Sotomayor is saying that, as Philip mentioned, the majority opinion says that these are foreign national versus American Japanese citizens. But for Sotomayor, it's really about, there are stark parallels, because the entire ruling in her dissent, they're saying that they're judging based on nationality, which is the issue that she has. And she's saying that, even though Chief Justice Roberts doesn't want to say that there is a difference, she says that there are, quote, stark parallels between the court's decision in Korematsu and the court's decision in Trump v. Hawaii. And so she first goes by saying that both policies rested solely on stereotypes of the specific groups that the individuals were members of. And she's kind of supporting Justice Murphy's dissent in Korematsu. And also that both exclusionary policies were sweeping, and they invoked very ill-defined national security threat, which kind of goes back to the precedent she mentioned, because she was saying that in the precedent Masterpiece Cake Shop v. Colorado Civil Rights Commission, they were saying it in a less pervasive way, which is why I believe that she said it was an ill-defined, invoking an ill-defined national security threat. And next, she argues that she's asking, like, where can we find, or in neither case, in Trump or Korematsu, there's no evidence from our own intelligence agencies outlining that there was a threat posed by these individuals. Like, she's basically posing the question, like, you would think that our government would have shown us something if they really did pose a threat. And again, she's asking, where can we find the information that from our top-notch intelligence agencies that verify these arguments of the Japanese in Korematsu and Muslims in Trump v. Hawaii being dangerous or a threat to national security? And finally, she says that there is strong evidence that impermissible hostility and animus motivated both of these policies, and as a result made the case rule as it is. So, she's criticizing the court's majority opinion, but I think that one quote that I found by Justice Ruth Bader Ginsburg quoted this, and she said, dissents speak to a future age. It's not simply to say, my colleagues are wrong and I would do it this way, but the greatest dissents do become court opinions, and gradually over time, their views become the dominant view. So that's the dissenter's hope, and that they are writing not for today, but for tomorrow. So although her dissent, wasn't the majority, I think it really spoke volumes to a lot of people who didn't like the court's majority. And in the end, these, you might have to edit this part out, but in the end, I think it was overturned, right? The court's decisions in Korematsu was overturned.
Yes, it was. Later on, it was overturned in a later case, and I think there was a settlement actually on behalf of the Korematsu family by my recollection. But
so, yeah, and I would just say I think that really spoke volumes to what Justice Ginsburg had to say a while back about how she's not writing for today, but for tomorrow. So these dissents had a future impact, and I believe that this one was probably like one of my favorites.
Yeah. Well, I'd like to thank everyone for viewing our podcast today. We hope you found it was informative. Whether you agree with the majority or agree with the dissent, it doesn't really matter for us. We just hope that you found this to be informative, and we hope that you join us next week when we talk about economic freedom, and we review the decision in the slaughterhouse cases, which are pretty interesting ones. So thank you guys for coming out and watching our podcast, and we hope to see you next week. Bye-bye.
Bye.